Chair lays out Senate Bill 152 and offers a committee substitute and recognizes Representative Harris to explain the bill. This is the Senate companion to Harris's 668. Is that right? Mm-hmm.
Thank you, Mr. Chairman and members, for the opportunity to lay out CSSB 152 before you today. This bill is the culmination of years of discussion with stakeholders to protect private property rights while giving groundwater conservation districts tools for more transparency. Currently, Chapter 36 requires districts to provide affected persons an opportunity to contest a permit or permit amendment. However, districts have the authority to approve permits without a public hearing. The law also allows the district board to delegate the authority to approve permits to the general manager. In both cases, affected landowners have no reasonable opportunity to be informed of the district's action on the permit. CSSB 152 requires notice of a permit or permit amendment that will prevent a landowner from being able to drill a well on their property or drill at a particular location on their property due to the district's spacing rules. In addition, the bill allows each GCD by local rule to determine who, how, and when notice will be provided. It also exempts replacement wells and emergency wells from the notice requirements so that permits can be expedited in those situations. CSSB 152 also allows a landowner to petition the district to conduct rulemaking. This change is needed in order to provide landowners with an alternative to filing a lawsuit when the district's rules adversely affect a landowner's rights to their groundwater. Notably, the attorney's fees provision of the original filed bill has been removed. Thank you, Mr. Chairman and members. If there are no questions, I reserve the right to close.
Are there any questions? All right. I'll call some witnesses. Chair calls Gregory Ellis.
He might be in a meeting.
Is Mr. Ellis with us?
No, testified.
Okay. He was signed up for the bill. Mr. Ellis was. Leah Martinson. He may show up.
Good afternoon, Chairman King, Vice Chair Harris, members of the committee. My name is Leah Martinson. I'm the Executive Director at the Texas Alliance of Groundwater Districts. I am here testifying in support of the committee substitute on Senate Bill 152. I will mention that we were opposed to the engrossed version of Senate Bill 152. TAG is a 501c3 membership organization. We represent 90 of the 100 groundwater conservation districts in Texas. Our legislative committee tracks legislation and only takes a position on groundwater bills where a 75% consensus standard is achieved. We did consider, as I mentioned, both the engrossed and the committee sub, and are happy to be in support of the committee substitute here. We appreciate the hard work that Representative Harris and his staff, along with Senator Perry, put into this bill, building consensus through the TWCA process, as well as through work with stakeholders over many months. It's resulted in a lot of positive changes. Importantly, as Representative Harris mentioned, the removal of the attorney's fees provision was important to our consideration of this bill. Those provisions, the attorney's fees provisions, were important in a deliberate part of Chapter 36, back when the bulk of Chapter 36 was codified. And they've been a topic of ongoing discussion for a number of sessions. We've actively engaged in those discussions, but ultimately most districts maintain and continue to maintain that those provisions should remain as they are. So with that, I will say that with the removal of attorney's fees, the other portions of the Senate Bill 152, the committee substitute, received near unanimous support of our committee. Section 1, the formal petition process, is a common sense measure. It tracks with TWCA consensus language that was developed. And, you know, it's a process that I think informally a lot of districts had in place. It just wasn't in their rules. And I think by putting it in the rules, it gives landowners a meaningful opportunity to engage and access their local district. The second section is a clarification to DFCs and what happens when a DFC is unreasonable, also a product of the TWCA consensus process, and something that we've supported. It's timely with the GMA process nearing the end of its 5-year cycle. And then finally, the notice provision that Representative Harris mentioned. Districts are in support of that, and they cited, you know, the importance of a couple different aspects of that in getting to that point. One is that it really deals with well-to-well spacing rules. The second is that it's only kind of hitting those landowners within the circle of influence of those well-to-well spacing rules. And third, that there are some exemptions in place for emergency wells, replacement wells, as well as if a district posts applications and locations at their office and on their website. So in short, I think that this, adds some meaningful transparency to Chapter 36 while giving districts flexibility in implementation. And with that, I'll close. Happy to answer any questions.
Thank you. Are there any questions for Ms. Martinson? If not, we appreciate you being here today. The chair also wants to point out that Representative Price is with us.
Thank you.
Thank you. Chair calls Sarah Kirkle. Did we have to spend an ash? Anybody on this week? Ms. Damon or Joy?
Thank you, Mr. Chairman and members. My name is Sarah Kirkle, and I'm with the Texas Water Conservation Association. I'm here to testify on the substitute for Senate Bill 152. As many of you know, TWCA is an association of water entities and professionals in Texas. Our members include river authorities, cities, groundwater conservation districts, other water districts, as well as industry, consultants, and others interested in Texas water policy. TWCA works to build consensus among our diverse stakeholders on water policy issues through our surface and groundwater committees. The TWCA Groundwater Committee has more than 150 members and has met in advance of the last 4 sessions to work through tough groundwater policy issues. As you know, we set a very high standard for these committees, requiring support from at least 90% of voting committee members to reach consensus. This past interim, the committee considered 6 items, including all 3 of the provisions for the substitute for Senate Bill 152. We are neutral on the substitute as a whole because we didn't quite reach consensus on the provision related to notice to affected landowners. We were very close. So we are very sorry that we're not able to support this right now. We do not have a position on that section of the bill. However, the other 2 provisions in the bill did receive the 90% threshold from our TWCA Groundwater Committee, and that includes both establishing a process for petitioning a GCD to initiate rulemaking, as well as clarifying which DFC should be included in a management plan submitted to the Texas Water Development Board. This language is identical to the language in House Bill 3801 by Representative Metcalf that the committee has already heard and which has already passed the House. TWCA strongly supports these provisions, which have also been approved by our board. Thank you for the opportunity to speak on the substitute, and I'm happy to answer any questions.
Thank you. I just want to say we appreciate the work that TWCA does every session on sorting through all of the different legislative measures that are introduced about this, and we value your input very, very much. Are there any questions? Appreciate you coming today.
Thank you, Mr. Chairman.
Chair calls Carlos Rubenstein. Please state your name and who you represent today and proceed with your testimony.
Chairman, members of the committee, for the record, my name is Carlos Rubenstein. I'm principal of RSA H2O, and I also assist Belding Farms and Cockrell Investment Partners on sustainable water management concerns. I am submitting comments for Senate Bill 152 by Senator Perry. The rulemaking petition process, including in SB 152, will provide a person with real property interest in groundwater to petition a groundwater conservation district to adopt or modify an existing rule. Petitions must be from in-district property owners. The proposed rulemaking petition process requires that a GCD act on such a request within 90 days by denying the petition or to initiate rulemaking in accordance to what was requested. In denying a petition, the GCD would be required to explain why the same was denied. GCDs are the preferred method of the state to manage groundwater. Providing in statute specific and clear rulemaking authority as much needed petition process gives greater local control to those most impacted by GCD decisions. Effective rulemaking could assist in addressing changed conditions between adoption of desired future conditions, the adoption of desired future condition process itself, and address groundwater management deficiencies within a district. SB 152 also provides for specific notice requirements that also increase transparency and awareness of actions that may impact existing users of water. Together, these changes can provide for a more sustainable management of limited groundwater resources. And for these reasons, we're proud to submit these comments for Senate Bill 152. Be happy to address any questions you may have.
Are there any questions for Mr. Rubenstein? We appreciate you coming today.
You bet.
Chair calls Ty Embry. Please tell us your name, who you represent today, and your position on this bill.
Sure. Ty Embry here on behalf of multiple groundwater districts in support and for a committee substitute. And just wanted to say thank you to all the committee members that have been involved, and Representative Harris for all of his work and effort, and Chairman Perry and all of his staff's work on this bill, and all the people that were involved at TWCA, the Groundwater Committee, that this is a product of a lot of people's effort. I think this committee substitute makes a lot of positive changes to Chapter 36 that will help in the future. And I wanted to say thank you to Representative Harris for listening to the groundwater districts on the attorney fees issue. That was a big deal, and really appreciate your listening to us. And I was co-chair with Billy Howe on the subcommittee that dealt with the petition for rulemaking to try to take what Representative Harris filed last session and work with him and his staff to make it improve it where we thought we could help, and tried to look at this agency rulemaking process, petition for rulemaking process, to try to see what we could learn from that. So proud to be part of that subcommittee, and proud to support this bill. So the committee substitute.
Any questions for Mr. Embry? Appreciate you coming today.
Thank you. Appreciate it.
Chair calls Judith McGarry.
Good afternoon, Chairman, members of the committee. My name is Judith McGarry. I'm the Executive Director of the Farm and Ranch Freedom Alliance, and I'm here on the bill. We think that there are many good things in the bill. There's a lot of positives. The reason I'm on it rather than for it is concern over the notice provision in the last section, and the allowance that the GCDs could simply give, website posting as their notice. Normal people, particularly in rural communities, are just not going to be monitoring a GCD's website forever in perpetuity. I mean, we're not talking about a specific time frame where they know, like, for the next 3 months, we need to be watching what this GCD is doing. We're talking for as long as they or, the next people who own their land need to be worried about their wells. We are, as someone earlier pointed out, this deals with a very discrete number of people, the people who fall within the spacing rules of the district. We think it would be reasonable to be providing actual direct notice to those individuals. And with that, I'm happy to answer any questions.
Thank you. Are there any questions? We appreciate you coming today.
Thank you.
Chair calls Gregory Ellis. Please state your name and who you represent and proceed with your testimony.
Thank you, Mr. Chairman. Glad I made it in time. My name is Greg Ellis. I represent a number of groundwater conservation districts around the state of Texas. I'm here testifying in favor of committee substitute for Senate Bill 152. There are several provisions in here that I think are important, not the least of which is to answer the question of which desired future condition applies in a management plan after there's been a determination that that desired future condition is unreasonable. We could either go with the one that was adopted 8 years ago, or we could go with the one that was adopted 3 years ago but has been declared unreasonable. This bill goes with the most recently adopted one. It makes sense because it says that you have to use the one that was last adopted. So until a new one is adopted that is more reasonable than the one that was declared unreasonable, the district should still have to meet that goal in its management plan. So that's an important provision. I think it solves a problem that resulted in some litigation this last time around with the Lone Star Groundwater Conservation District. I think that they were put through a lot of stuff there, as was the Water Development Board, that this bill would have helped avoid had it been the law at the time that that happened. I really don't need to cover all the rest of the provisions there, but I want to let you know that we are in favor of the committee substitute bill. I'll be happy to answer any questions.
Thank you. Any questions for Mr. Ellis? We appreciate you coming today.
Thank you.
Yep. Chair calls Billy Howe. Please state your name and who you represent today and your position on this bill.
Thank you, Mr. Chairman. Billy Howe, Associate Director of Government Affairs for the Texas Farm Bureau, and we support the committee substitute on Senate Bill 152. Don't want to take y'all's time. Obviously, y'all have heard about what the bill does and how it's good for landowners, and that's why we support the bill. So we appreciate y'all's favorable consideration.
Well, we appreciate the work you did on this. I know that this is a piece of legislation that y'all worked on for quite a while, and I'm personally grateful for your work on it. So, are there any questions for Mr. Howell? Appreciate you being here today.
Thank you, sir.
Anyone else wishing to testify on, for, or against Senate Bill 152? I'll read off, hearing none, I'll read off the names of the folks that chose not to testify. Letitia Vandepute, San Antonio Chamber of Commerce, for the bill. We do have a TCEQ resource witness, if anybody needs that. We also have a Texas Water Development Board person, if we need that. Then we had Shauna Sledge, attorney, Upper Trinity Groundwater Conservation District, and others, for the bill. Andrew Weir, Simsboro Aquifer Water Defense Fund, and self, neutral on the bill. Hope Wells, San Antonio Water Systems, for the bill. Peyton Schumann, Director of Government Affairs for Texas Southwestern Cattle Raisers Association, for the bill. Ryan Shkwobarczyk, Director of Texas Nursery and Landscape Association, for the bill. Jerry Valdez with Quadvest Utilities, against the bill. Vanessa McDougall, on behalf of herself, is software engineer, against the bill. Greg Vunderich, on behalf of himself, against the bill. Robert Howard, Brush Country Groundwater Conservation District, for the bill. Al Zito, on behalf of himself, for the bill. And Calvin Tillman, on behalf of himself, for the bill. Chair recognizes Representative Harris to close.
Thank you, Mr. Chairman and members. I don't really know what to do having all these people agreeing on this issue now. We've been fighting over it for so long, but
Yeah.
I really do want to thank all of the stakeholders who have put so much time and effort into coming up with something that both protects landowners and works for the groundwater conservation districts. Thank you, Chairman King, for your hard work on getting this bill to where it is now. And with that, I close and request your favorable consideration of this bill.
Any questions? All right. If there are no objections, the chair withdraws the committee substitute. Hearing none, the committee substitute is withdrawn. If there are no objections, the bill will be left pending at this time. Chair hears none. This bill will be left pending.